This new Part 3, which I and the Labour Party are urging the Parliament to vote for, puts a requirement on the Accident Compensation Corporation to conduct an annual review of the effect of the Amendment Act on injured people. We know that this amendment bill significantly cuts the entitlements of people that are injured. Now, most people in New Zealand never suffer a serious injury that has them off work long term, thankfully. And so, thankfully, most of us never experience the consequences of having a long-term injury and all of the bad things that flow from that, including loss of work, pain, lost opportunities, constrained abilities to do other things that you used to do before your accident. When you change the rules in fundamental ways such as those which are brought about by this bill, the impact of that on real people must be considered. Now, we've heard already that in prior parts that the change that's being made to when someone is deemed to be vocationally able and therefore pushed off the scheme, but it's important that we recall that just because they are deemed to be vocationally independent, because in theory they could work at some job for 30 hours per week, doesn't mean to say that they will get a job. Now, it's absolutely clear that the return to work following injury rules under the scheme are already tough. In the minority report from the Labour Party on the Select Committee, we referred to a published study which was undertaken by Hazel Armstrong and it was published in the New Zealand Law Review, and it showed that even under current rules, which are made tougher by this legislation, but it dealt with the current rules, that people who were deemed ready for work and therefore pushed off the scheme didn't always get work. Indeed, after quite a significant period, the majority of them were still not in full-time work. In fact, the study found that of those that were found to be vocationally independent and therefore pushed off the scheme, only 32% of those who were deemed work-ready obtained full-time employment, 21% were in part-time employment, 22% were on a work and income benefit, and 10% were not working at all and were on no benefit, probably because their partner was of an income that meant that they weren't eligible for any other benefit, and 9% remained on weekly compensation. So the vast majority of long-term injury sufferers after being exited the scheme didn't go back into full-time work. And so we want to see how this plays out, how this changes. This will be changed to make it even harder on those long-term injured people, and we want those additional costs to be assessed by Accident Corporation, because of course the reality is that these changes don't cause costs following injury to go away. They just move them on to the injured person. It's not like all of a sudden pushing them off the scheme means that they are miraculously cured. All it means is that they're no longer getting any accident compensation, they're no longer entitled to any further rehabilitation treatment because of some of the other changes that have been made. They could be a former person in quite a well-paid occupation that was a technical occupation, and they could be rehabilitated to the stage that they can stack shelves in a supermarket, but then pushed off the scheme and get no further assistance to rehabilitate them back to the point when they could have carried out their further job. So that might, for example, have been a labourer where they could have got paid a bit more, or working as a builder, but they don't get any further physiotherapy or any other services or orthopaedic interventions to help them get well enough to do their prior occupation after they're pushed off the scheme. So effectively the cost of that rehabilitation either can't be afforded or is paid for by the injured person. And so those effects, in the opinion of the Labour Party, ought to be assessed and reported upon, and that's why I put this amendment, this new clause 60, in the hope that the House will support it. Thank you.
Chair. I call Michael Woodhouse.
I move that the question be now put.
Mr Chair.
I call Sue Moroney.
Mr Chair, it is a pleasure to get a call, albeit in urgency, for a bill that the Labour Party does believe, and that's why we're putting forward new Part 3, because when things are done in urgency, rushing through the political process, not listening to what people are saying, that is the very time that reviews are so important. Because when legislation is made in haste, when it has not been considered seriously and deliberately and using the normal process, that is the very time that there are unintended, what we call in this House, unintended consequences that occur. And, Mr Chair, there could be no more serious issue for unintended consequences to occur than for some of the most vulnerable in our society, people who have been injured, often, mostly, through no fault of their own. And so, Mr Chair, I do believe that, and I hope that this House will seriously consider new Part 3 for this bill, because what we do already know is that even though it hasn't been a legislative change, the change to the practice under the national government of how people are treated for sensitive claims under ACC, which has not even been a legislative change, but we know that the numbers are horrific in terms of the number of people who are no longer getting treatment for that very important work. So, for example, in the area that I come from in Hamilton, in the Waikato, the number of sensitive claims that have been accepted by ACC has reduced in the order of 70%, Mr Chair. So that is 70% more people in our community wandering around without the counselling help they need after having suffered serious sexual abuse. And that's an example of the sorts of numbers that can happen through just a simple policy change that has happened under national government. Now here we are actually doing legislative change that will have serious consequences for people who suffer hearing loss through their work, will have serious implications for people who are the victims, or the family of people who have committed suicide, or perhaps people who have attempted suicide themselves. And we don't know, Mr Chair, we don't know what the impact of these legislative changes will be. I've heard no information coming from the government on any research or any evidence that they've been able to put before this House to say what the impact of these changes will be. So under urgency, into the unknown goes this government once again with the most vulnerable in our society, and yet I do hope that they will pick up this opportunity to say, well, look, we're only human and maybe we haven't got this quite right, and therefore we would like to take up the Honourable David Parker's proposal to review what the impact of these changes have been annually, not only just in 12 months' time, Mr Chair, assuming that this very bad piece of legislation does go ahead and the government benches, even though some of their members, and that's been quite obvious from speeches over the course of the last 24 hours, they don't actually understand what they're voting for. But assuming that they do still go ahead and vote for this, then yes,